testimony has failed to satisfy the requirements for a cause of action in either intentional or negligent infliction of emotional distress. Well, that's up to a jury, not to a judge. Glendora asked, what concluded the deposition testimony? I don't know what concluded it. Do you? Not from that. Glendora has never failed to satisfy the requirements for a cause of action for intentional infliction of emotional disturbance, for insulting, abusive language, for harassment, or for violation of the White Plains Noise Ordinance. Karamitsos has not even seen the videotapes. Karamitsos continues her nescience all over the place. In addition, the witness has not sustained any physical or economic harm. While Glendora says, learn the law. Physical harm is not the issue. The law is intentional infliction of emotional disturbance with no physical effect. Freedom from mental disturbance is a protected interest. Damages may be recovered on a cause of action for emotional disturbance. New York law allows recovery for mental disturbance in the absence of a physical impact. That the force proceed directly from, there is no requirement that the force proceed directly from the defendant to the plaintiff. Although fraud, extra litigation, and a measure of speculation are possibilities if recovery is permitted for fright, there is no reason for a court to eschew a measure of its jurisdiction. Glendora does not sleep well at night. Many nights Glendora has been up since 2 a.m. because of the Larkins. Last night was one of them. This interferes with her appetite, making her hungrier because she works that many more hours a day. Hence, she is hungry all the time, eats more, and has put on 30 pounds, or at least 30. This has thrown off her physical appearance. She looks bad. In addition, she looks bad on TV and chat with Glendora. She would look bad in commercials if she got any. The intentional infliction of emotional disturbance by the Larkins has caused wrinkles. It has caused loss of skin tonus. It has caused flab. It has caused a double chin, which Glendora never had before. Every day it is like Dorian Gray. Economic harm. The law breaking of the Larkins has caused Glendora severe emotional disturbance. It has cost Glendora thousands of dollars in video equipment, audio equipment, paper, office supplies, postage, printing, gasoline, and carware. It has cost Glendora thousands of dollars in lost business because of the time stolen by the Larkin defendants. Karamitsos writes, nor has she alleged any psychological or psychiatric harm. Glendora writes she has suffered a severe psychological and psychiatric harm. Nobody can look at the record in print and on videotape and fail to see the psychological and psychiatric harm, the law-breaking of the Larkins, the law-breaking of their crooked lawyers, and the law-breaking of the prejudiced Judge Wood Court have caused her. There is no way this case can be dismissed until Glendora has, according to right, an opportunity to present witnesses to testify that change it has made in Glendora. Glendora never leaves her apartment nor returns home without a recorder because of having been attacked and abused so many times. If it is not recorded, COSA tries to get out of it. How would you like to live like that, Judge Wood and Paul Carlucci, always in fear of being attacked when you exit and enter, or go to the laundry area, or go to your cellar locker? Same has been an egregious stress and strain on our 40-year marriage. There was hardly any time celebrated on our anniversary, Christmas Day. Anybody with any mind or here can figure this out. Karamitsos and the rest of them are devoid of both. Heart, it should be. Anybody with any mind or heart. They sold their souls long ago. Glendora has been up since 1:30 a.m., January the 21st, 1995, Saturday, to now 10:08 a.m., writing her answers to these Karamitsos lies. 8.5 hours. She didn't help Franklin with a breakfast nor pack him a lunch. Franklin is losing weight rapidly. He is 6 foot 1 inches and only 153 pounds. Karamitsos writes, mindlessly and heartlessly, the plaintiff has not sought counseling from any psychologist, psychiatrist, or other mental health care provider to date. Glendora writes, what does this prove? Read the law. There may be recovery for the intentional infliction of emotional distress without proof of the breach of any duty other than the duty to refrain from inflicting it. And guilty are Andrew Larkin and Kevin Larkin. Now read the rest of it. New York adheres to the majority view, which expressly recognizes the existence of an independent tort of intentional infliction of emotional distress. A few states have expressly refused to recognize this independent tort, or apparently have not ruled on the issues, but New York has. A cause of action for intentional infliction of severe emotional distress may be maintained. There may be recovery for the intentional infliction of emotional distress without proof of the breach of any duty other than the duty to refrain from inflicting it. One who by extreme and outrageous conduct intentionally or recklessly causes Severe emotional distress to another is subject to liability for such emotional distress. Liability is found only where the conduct is so outrageous, as it was in this case, in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Where severe mental pain or anguish is inflicted through a deliberate and malicious campaign, and that's what we had here, of harassment, and still have, or intimidation, a remedy is available in the form of an action for the intentional infliction of emotional distress. Where a defendant's conduct is extraordinarily vindictive, it may be regarded as so extreme and outrageous as to give rise to a tort cause of action for emotional distress. The applicability of the doctrine of liability for intentional infliction of extreme emotional distress may be questionable where the conduct complains of falls well within the ambit of other traditional tort liability, such as malicious prosecution or abuse of process. Particular acts are actionable when done without legal justification or, as the law says, done maliciously. To make a lawful act actionable, it must be entirely malicious, without any other motivation, and must be directed exclusively toward the injury and damage of another person. These lawyers have doubled Glendora's emotional disturbance that Judge Woodcourt has tripled it. Writing this paper and refuting the lies and essence of Karamitsos and her endless chatter have quadrupled it. This paper is murdering a ream of trees, and law clerk Carlucci does not even know the rule of the United States Supreme Court: use both sides wherever possible, but then Clerk Carlucci and Judge Wood are running a unilateral court, protecting the son of Father Cousins, a friend from a decade ago. Karamitsos writes, "It is well established under the law of this state that in order to maintain an action for intentional infliction of emotional distress, 4 elements must be present: extreme and outrageous conduct by the defendant, which is what we have here; intent to cause or disregard of a substantial probability of causing severe emotional distress, which we have here; a causal connection between the conduct and the injury, yes; and conduct resulting in severe emotional distress to the plaintiff, yes." Glendora writes, Karamitsos left out with no physical effect. Glendora has already proved these 4 amply in print, on videotape, and on television. And lawyers' court have not even seen the videotapes. And Karamitsos leaves out an important element, that defendants acted with a desire to cause such disturbance. And she left out a second element, that defendants acted under circumstances that made it certain defendants knew that mental stress would result. Glendora has proved these 2 elements also. Glendora wishes to draw judicial attention to the guarantee of genuineness, Here is a statement of the same within the context of the law and some case citations. In cases involving intentional or wanton or willful torts, as in the case of Andrew and Kevin Larkin, and James, Daniel, Roberta Walsh, Theo, and Nella Alpucci, recovery is allowed for mental anguish unaccompanied by physical conduct or injury, or for a physical injury received solely as a result of the mental anguish. In an action for a tort based on malicious and wrongful acts of the defendant, which is what we have here, where the acts result in substantial damages, the jury is entitled to consider not only the actual money damages, but also such other damages as necessarily arise out of the acts, including damages for mental suffering and anxiety, if the effect of such damage is to produce suffering and anxiety. A wrongdoer who has caused physical injury to the plaintiff may be held liable for the ultimate result flowing from his act of negligence. This is not the case here. Karamitsos writes on her next unpaginated sheet, in order to maintain an action for negligent infliction of mental distress without physical harm, the following are necessary: a breach of duty owed directly to the plaintiff by the defendant, and Andrew Larkin had such a breach of duty toward me, so did Kevin. Their duty was not to inflict it. The breach of duty must either endanger the plaintiff's physical well-being or safety, as it did here, or cause the plaintiff to fear for her own physical well-being and her safety, as it did here, or the plaintiff must be exposed to an unreasonable risk of injury or death as a result of the breach of duty. Glendora states she has proved number one. Glendora has been fearful many times for her own physical well-being, for Franklin's, and for the two cats, and for her home and possessions. Glendora testifies that she believes it was Kevin Larkin, with his agility at climbing walls and peering into windows, who entered Glendora's apartment and turned on the kitchen hot water faucet, flooding the sink cabinet, all the pots and pans, ruining the detergents, and flooding the floor of the cellar below. That was the day I was on jury duty. And every time she leaves her apartment, she's careful when possible to leave when nobody is around. Sometimes she has Franklin pick her up at the Rutherford Street side so people will not see she has left her apartment unoccupied. Glendora quotes the law in the cases. There may be a right of action for the negligent infliction of physical or mental injury, even though such injury was caused by fright negligently induced without any physical contact. Under certain circumstances, an action will lie for negligent infliction of severe mental distress. There may be recovery for emotional harm, even in the absence of fear of potential physical injury to one subjected directly to the negligence of another, as long as the psychic injury was genuine, substantial, and proximately caused by defendant's negligent conduct. Well, as Glendora stated in her oral deposition October 25, 1994, her big cause of action against Andrew Larkin is that he cooperated with and even encouraged his son Kevin to engage in this deliberate, malicious, vindictive campaign of harassment and intimidation so extreme and so outrageous and going beyond all possible bounds of decency and utterly intolerable in a civilized community. Supra is a much stronger cause than what Karamitsos listed on the preceding page. Clearly, the plaintiff, based on her own testimony, the pleadings and the detailed logs, has satisfied all the elements necessary in the above-mentioned torts, and therefore Karamitsos' motion to dismiss Glendora's complaint must be denied, and the court must stop favoring the Wilson Bave law firm with every delay and obstacle to keep Glendora's case from going to trial where it belongs. Further, the Larkin defendants in Convoy, Koza, Cousins, Odell, McGrath, and Karamitsos, must be punished with costs and sanctions for their lying, stealing, cheating, and bungling. Their defense has been frivolous and has no merit anywhere. Karamitsos has to be a special kind of dehumanized to call frivolous an action seeking justice for more than 1,700 injuries done to plaintiff. She is soulless, and here is a nadir. Karamitsos writes, "The case at bar is the plaintiff's conduct and actions toward the defendants and others, including the children involved, the court personnel, the Harrison police." Well, this didn't happen in Harrison, Karamitsos. This happened in White Plains. Do your homework. Department, the other tenants, your affirmance office, and the list continues. And Glendora counters, a person being murdered is going to cooperate with the murderer and not resist. Is this intelligent? Karamitsos' first paper in January 1994, 34 days late, was bad enough, but this one sinks to a new low. Glendora will tell the New York Bar Association, the Westchester Bar Association, Karamitsos' alma mater, as soon as she looks it up in Martindale-Hubbell, and Gary Casella, Grievance Committee, 9th and 10th Judicial Districts, at the same address as Bendish. With a record like this, Karamitsos could never fill out the application to be admitted to the bar of the United States Court of Appeals or the United States Supreme Court. Please read the oath of admission. This is what you have to fill out if you're a lawyer and you want to be admitted to the bar of the United States Supreme Court. You have to say, "I blank blank do solemnly swear that as an attorney and as a counselor of this court, I will conduct myself uprightly." You call what she did uprightly. "And according to law, and that I will support the Constitution of the United States." I don't. Of what conduct and actions toward the defendants and others does Karamitsos speak? Here is what Glendora's conduct toward the defendants and others, including the children involved, consisted of. From April 12, 1993 Easter, when the children violated the law, refused to stop when asked, violated the law the next day, the day after, and practically every day, and their parents wouldn't speak to any of them. Think how much worse these defendants would have acted if Glendora and Franklin had said anything. Glendora never broke a law. Glendora kept a record in print and on videotape. Glendora publicized the record. Glendora summoned the police to protect her and her husband, her home, and her rights. When Paul Carlucci and Judge Wood denied Glendora's due process, Glendora protested. And what is wrong with this? And what law was broken? Glendora stood up for the rights Judge Wood and Paul Carlucci stole. She protested Carlucci's insults, spite, prejudice, malice. What law was broken here? Kara Mitzos mentions the Harrison Police Department again. Will somebody set her straight? The Harrison Police Department does not have jurisdiction over matters in White Plains. This is fully familiar with the facts and circumstances. Glendora gets along fine with the other tenants. They are good tenants. Walsh and Alpucci are not and must be evicted. Glendora likes all the other tenants. The tenants who took over the Larkin apartment are perfect. I gave the little girls in apartment 3C 2 loaves of bread that she baked and 3 little books. She gave Francis across the hall in 1A a candy cane this morning. He's about 5 years old. He's very cute. Your affirmance office, Kara Mitzos says, quote, take a look at the abuse your affirmance office has heaped on Glendora since January. Glendora is supposed to take that abuse of lying, stealing, cheating from anybody, would you? Kozer, your beloved cousins, Conboy, Odell, McGrath, and Kara Mitzos have acted rotten to the core. They have degenerated as human beings. They're being disciplined and returning to what a human being should be is mandatory. Even with the public record, they have cut so far. They continue to make it worse and never reform. Exactly the same level as the Larkins for 1 year, 2 months. They just never catch on. Cause and effect. What starts it? What is next? When the law breaking stops, the videotaping stops. Affirmance office, Kara Mitzos writes, Glendora is very good to the receptionist who answers the phone and to the secretaries there. Even though they work for crooks who do such evil acts, Glendora tells them jokes and listens to their concerns of the day. And the list continues, Kara Mitzos writes. Glendora requires substantiation. Glendora did what was right. She fought evil on every front. She stood up for what was right, good, decent, and law-abiding. She stood up for society. This was at tremendous sacrifice of her well-being, husband, TV show, TV business. At 11 a.m., Cozens got up precipitously without Judge Wood saying the conference was over or without any indication Glendora was done. He got up and left as if he were in charge of the conference, January 18, 1995, and walked out of the robing room. Glendora said to him, just a second, could I please have your card? For 5 seconds, Cousins felt in his right jacket pocket, said nothing, and left without a word. He didn't say, I'm sorry, or yes, or no, or goodbye. And this is how plebe every one of them is. Conboy, Cousins, Koza, Odell, McGrath, and Kara Mitzos. 4 years of high school, 3 years of law school, and they act like gutter snipes. They act like Kevin and Andrew Larkin, no class. Glendora said to Judge Wood he would not give me a card. And Judge Wood said, that's Cousins, not the father, but the son. But he's big and tall like his father. When did you move to Westchester? Judge Wood said to Glendora. Glendora, 1984, when Franklin retired as a reporter from the Buffalo News after 27 years, plus 10 years in the Springfield Union, Massachusetts. Judge Wood, oh, he was dead, meaning Cousins' father. Immediately, Glendora and Franklin had the answer as to what was happening in Judge Wood's court. Why over 12 decisions had come in favor of Wilson, Babe, Comboy, and Koza, Cousins, Odell, McGrath, and Kara Mitzos, and not one in favor of Glendora. Godfather Wood was going to look out for the son of deceased father Cousins by hook or crook. And that is why Glendora has lost every plea unilaterally. Glendora is much wiser now. Now she understands the motive. The light here is awful. The spite and malice of Paul Carlucci she figured out long ago. Glendora refused to to bow to the arrogance of the law clerks in the Westchester County Courthouse Tower. Add to this Carlucci's arrogance, to which Glendora will not succumb, and his consequent spite and malice ever since. This explains the dippy decisions based on using two sides of the paper and single spacing. It is all clear to us now. This explains why Carlucci would not recuse himself. He had to stay there to protect the son of Daddy Cousins, good old friend for 2 decades of Judge Wood. 3 minutes after the cousin's son left, something was said, "Hi, Jenny," to which Judge Wood commented to Glendora, "You are so mean to their lawyers." Glendora was aghast at 1, Judge Wood's blatant prejudice, 2, his total insensitivity to the injury these lawyers have done Glendora, 3, his incredible unfairness and bias, and 4, his inadvisable exposure of the fact. Now you know why everything from the Judge Wood Court has denied Glendora's First, Fifth, and 14th Amendments. Rights to due process, a judge shall have no personal interest in the decision. On the basis of what has happened here, Judge Wood should immediately recuse himself. He has a personal interest in what happens to the cousin's son. Most law firms and judges would realize you can just go so far. But this pair never seems to catch on. Young Kevin Larkin Karamitso's rights, whom the plaintiff believed to be 8 or 9 years old, and his playmates, have been repeatedly videotaped and humiliated on local television on a weekly basis for the last year and a half, which has resulted in almost daily teasing by classmates and friends. Glendora says, well, then why did they not cease the law-breaking? The videotaping happened only when they chose to break the laws and violate Glendora's rights. No law-breaking, no videotaping. Why is Karamitso so cozy, about not giving Kevin's age? Interesting point, isn't it? Karamitso's rights. The plaintiff has also continued to belittle, humiliate, and personally attack the Larkins on her television show even after they moved out of state. More recently, see paragraph 18 of plaintiff's January 6, 1995 correspondence, annexed here to is Exhibit E. But Glendora states, "Hi, Jeannie. Hi, Jeannie, girl. When the Larkins moved out, Koza Conboy cousins Odell, McGrath, and Karamitsos picked up with the law-breaking and carried on. So this had to be videotaped and cablecast. The public has to know how bad lawyers and courts are. They must not get trapped, as Glendora did, believing what she was taught in school: if you're wrong, go to court and get justice. No, you can't believe that. You can't get trapped the way I did. But the Koza crowd kept up the law-breaking, as did the Judge Wood Court with Carlucci. So the tiny 8mm tape wheels keep rotating. Again, it is no law-breaking and no videotaping. If there's no law-breaking, there will be no videotaping. You're a good kitty, Katie. Ginny, you're a good kitty. And calculate how long this motion of Karamitsos and the cross motion of Glendora will be on TV, probably for weeks. Here are lies 20, 21, and 22 by Karamitsos. There are so many I am losing count. It is evident, Karamitsos writes, that the plaintiff is utilizing the court system solely to harass her co-tenants and create material for her television show. Supreme Court, Judge Silverman did not think Glendora's lawsuit was frivolous and meritless when he ruled that Cablevision had broken a state law. The U.S. Court of Appeals, the prestigious Second Circuit, did not think Glendora's lawsuit was frivolous and meritless when it vacated on January 11, 1995, Judge Bryan's decision and remanded. The appellate term did not think Glendora's lawsuit was frivolous and meritless when they vacated Judge Holden's decision favoring Gallicano. Judge Freer did not think Glendora's lawsuit was frivolous and meritless when she granted Glendora's motion to dismiss Gallicano's complaint. This was on January 4th, 1995. Well, let's try again to teach Karamitsos the legal definition of harass. A person is guilty of the offense of harassment when, with intent to harass, annoy or alarm another person, he engages in a course of conduct or repeatedly commits acts which alarm or seriously annoy another person and which serve no legitimate purpose. What would Karamitsos and 99% of the lawyers know about purely anyway? Franklin is washing the Lincoln all alone out in the cold. Glendora should be helping him, but again she has to stay in and refute Karamitso's endless lies and set the record straight. It is 3:16 p.m., January the 21st, 1995, Saturday, and Glendora has worked 13 3/4 hours so far on her cross motion. This is another weekend ruined by Andrew and Kevin Larkin, Koza, Conboy, Cousins, Odell, McGrath, Karamitsos, Carlucci, and Judge Wood. Glendora has asked Judge Wood for a trial readiness certificate ever since July 1994, but he has allowed one obstacle and delay after another. The January 18, 1995 conference was supposed to be a trial readiness conference. The last thing Judge Wood said at the October 31st, 1994 conference, after the court clerk told him about the January 18, 1995 trial readiness conference, was, Judge Wood said, "I'll have my motions decided by then." But we are told January 18, 1995, no trial readiness, because motions are not decided. Why? Paul Carlucci was out sick 2 weeks in December. And Glendora adds that the entire courthouse tower was shut down from Christmas to after New Year's. No wonder this case has taken 1 year and 2 months so far. Even if Paul Carlucci was out for 2 weeks, a judge ought to be able to carry on. A judge ought to be able to read a paper, look up the law, and make a decision. That's what he gets paid for, and $113,000 a year, folks. When Glendora asked January 18th a third time for trial readiness, Judge Wood said, "You keep making motions." And Glendora said, "I did not make one of those motions before you." It was Koza, Cousins, Conboy, Odell, McGrath, Karamitsos, It would be best not to play with a microphone cord, Ginny. Koza, Conboy, Cousins, Odell, McGrath, and Karamitsos always fix it so Glendora does not have time to answer their motion, and so Glendora loses 7 days before the return date so they can make a reply affidavit, and Glendora cannot do a SIR reply. Glendora will do a SIR reply and read it on television. CPLR states that no discovery can go on while there is a motion before the court. There is a motion before the court. Karamitsos, and then Odell has one, and Conboy has one. You see how they do? They make these motions just to delay going to trial because they know they're going to lose at trial. How is this for circumlocution, Glendora asks. Karamitsos writes, "This behavior, coupled with the fact that the plaintiff harasses almost every resident of her condominium complex, most recently with an eviction proceeding against a co-tenant, as well as the local police department, local court system, and even the governor of the state of New York with her absurd correspondence in which she defames the names of your firm's clients, should be put to an end." I can't quite remember harassing the governor of the state of New York. That would be Cuomo. I certainly didn't vote for him because of the condition the New York State Division of Housing and Community Renewal is in. And what law does this break, Glendora wants to know. Let's start by trying to teach Karamitsos the harassment law. This is a popular number with her. A person is guilty of the offense of harassment when, with intent to harass, annoy, or alarm another person, he engages in a course of conduct or repeatedly commits acts which alarm or seriously annoy another person and which serve no legitimate purpose. That's what Kevin Larkin did over and over again. C, harasses almost every resident of her condominium complex is a lie. Glendora likes the tenants in the other 13 apartments. This is not a condominium. This is Karamitsos, fully familiar with the facts and circumstances. Oh, yeah. Tenants do not own the apartments nor manage them. The complex is 16 identical apartments, all two-bedroom, owned by John Porzio and is regulated by the New York State Division of Housing and Community Renewal under the Emergency Tenant Protection Act. Karamitsos is doing fine on fully aware of the facts and circumstances. She is more deficient here than even Odell, Conboy, and Koza. There is no question that Walsh and Alpucci, by their own choice, have violated the landlord's rights and the tenant's rights. They must be evicted. They have chosen their course. All they had to do was leave Glendora alone, which they chose not to do. Harasses the local police department is not substantiated. Where is Karamitso's proof of this allegation? Harasses the local court system. Where is the substantiation for this? And then Karamitsos wonders why Glendora does not like her, Koza, Comboy, Cousins, Odell, and McGrath. You call this a grown-up legal paper that Karamitsos has written? And even the governor of the state of New York, now which one, Governor Pataki or former Governor Cuomo? Neither one. Defames the names of your affirmance clients, they cut their own record. Again, Glendora says, no law breaking, no videotaping. Quote, should be put to an end? When is Karamitsos going to end these baby sentences? Are you sure Kevin Larkin didn't write this paper? Karamitsos, Glendora's never met her, must be very young. She is certainly very green. Certainly the law breaking of Koza, Comboy, Cousins, Odell, McGrath, and Karamitsos must come to an end, certainly. What law was broken here? Violation of Glendora's freedom of speech. Will this never come to an end? In addition, Karamitsos says, to verbally abusing, that's a split infinitive, the adult defendants in this matter, the plaintiff has used the judicial process to harass other individuals, such as young Kevin Larkin's friends, so referred to by the plaintiff as the 4'10" black boy and dark-skinned Mexican, also known as the Little Runts. There is no excuse for such language or conduct, and it should not be excused. There is no excuse for such conduct. She really actually wrote this. Here, I'd like to have you just see it. Right there. This one right here. There is no excuse for such language or conduct, and it should not be excused. What law was broken here? She must be very young. Young Alexandra Karamitsos, like young Kevin Larkin. What is this young Kevin Larkin? Why are they covering up his age? Referring to the two boys as standard identification. Glendora's heard it in criminal court, where she monitors dozens of times, and she's heard it from the police. This little runts is a lie, the second time. Kevin Larkin is a runt, as Glendora said. Oh, that must be it. Kevin is older than 8 or 9, maybe 11 or 12, and is small for his age. Yes, that must be it. Karamitsos gets the redundancy award for January 1995. There is no excuse for such language or conduct, and sick, no comma, it should be excused. The end is in view. Maybe only 2 more hours of this affirmation. In light of the above, it is respectfully submitted in the court that the plaintiff not only be ordered to reimburse the defendants for all the costs expended in defending this matter, but should also be sanctioned pursuant to CPLR 8303A and 22 New York CRR Civil Rules and Regulations, Part 131 for frivolous conduct. Glendora says vice versa. The converse should be ruled. Karamitsos says, in view of the fact that there are numerous individuals who probably would have had a valid claim for defamation against the plaintiff as a result of this frivolous action, court-imposed cause and sanctions are not unfair, unreasonable, or unjust given these circumstances. What a pathetic paper. Glendora says vice versa. The converse should be ruled. Even Judge Wood, with all his protection of the Wilson-Bave group, could not rule on this vague, vagrant, and loquacious paper. We are up to the last sheet of this so-called affirmation, unpaginated, of course. In the tradition of all the great Greek philosophers, it should be, Plato and Aristotle, Karamitsos should be able to reason better than she does. Maybe Judge Malonis can help her. Karamitsos does not seem to understand cause and effect. The cause is the law-breaking of Andrew and Kevin Larkin, of Koza, Comboy, Cousins, Odell, McGrath, and Karamitsos. The effect is Glendora standing up for her rights and reporting the record, reporting the cause. We are up to the last page of Karamitsos' affected affirmation. Affected affirmation. This lawsuit is yet another example of frivolous litigation by the same individual pro se plaintiff, she says. Glendora, is there anything new here? Karamitsos, your affirmant would request this honorable court to dismiss this instant lawsuit and to further issue an order preventing this pro se plaintiff from commencing any additional pro se lawsuits without advance permission from the administrative judge. What basis is this? for the dismissal. What basis has she possibly given for dismissal? Glendora, dismiss it on what grounds? A, I haven't read any grounds yet for dismissing a lawsuit where Glendora was injured 1,700 times, plus all the injuries of the crooked lawyers and of the court. This is violation of Glendora's right to due process, First, Fifth, and 14th Amendments. I haven't read anything that Andrew and Kevin Larkin did not break 4 laws: intentional infliction of emotional disturbance with no physical effect, insulting and abusive language, harassment, White Plains noise ordinance. I haven't heard anything that they didn't do that. Glendora proved that they did. Defendants have no defense, obvious from this meandering affirmation of Karamitsos with all of its errors. Defendants never will have a defense. How can a court dismiss a lawsuit when the court has not seen the evidence? No witnesses have been heard, no trial has been had, no merits have been dealt with. These are small items, of course, in court procedure, First, Fifth, and 14th Amendments. Glendora just met with Judge Ingracia after the Judge Wood Conference on January 18, 1995. She rather doubts Judge Ingracia would do such a silly thing. Karamitsos endangers herself. Pro se is a civil right. Glendora's pro se right is a matter of constitutional right, and every judge takes an oath to support the Constitution of the United States, which Glendora will videotape with our 4 new judges on January the 24th, 1995. Judge Ingracia gave Glendora permission to do so. Karamitsos says such an order will prevent future frivolous litigation by this pro se plaintiff. Such an order would land you all in the United States District Court for violation of civil rights. Warning, pro se prejudice is a dangerous violation. This is another cause of action for the federal case on emotional disturbance with no physical effect. Judge Wood must have told Cousins that no matter what Karamitsos wrote, the court would grant a motion to dismiss. This complaint has to go to the Grievance Committee and to the Commission on Judicial Conduct. The Commission on Judicial Conduct finally got Glendora's respect somewhat. They sent her a copy of their annual report and about 150 judges with discipline or discharge. But Glendora has never seen Gary Casella stop one bad lawyer. Karamitsos really had a hard time in those $600 depositions, $800 deposition, to find anything at all to use against Glendora. That's true. She certainly failed. You see, lawyers, how much better it is to live by the law. Then you can just tell the truth, and everything is very pleasant. She really had to work hard to find anything in those depositions. In fact, she never found anything to use against me. Karamitsos says, in conclusion, thank heavens, it is respectfully submitted to the court that based on this affirmation, the attached memorandum of law and the pleadings, proceedings, and depositions transcripts attached here too, that plaintiff's action be dismissed as a matter of law pursuant to CPLR 3211A7 and or CPLR 3212 for failure to state a cause of action, and that the court grant costs and sanctions against the plaintiff and any other such relief as this court may deem just and proper. Glendora says, based on this affirmation, I would certainly hope not. This is a pro se lawyer if I ever read one. Karamitsos concludes, wherefore it is respectfully submitted that plaintiff's action be dismissed in its entirety, and all costs and sanctions allowable by law be imposed for plaintiff's frivolous claims and conduct, and that the court grant such other and further relief as it deems just and proper. White Plains, New York, January 11, 1995, and I'll show you her signature. And you notice that it isn't notarized. Okay? It's just a lawyer's affirmation. And who can trust a lawyer? Glendora, what is frivolous about being injured 1,700 times by 7 law-breaking defendants, 2 of whom are Larkins, breaking 4 laws? Plaintiff did not break any laws. Note again, there is no declaration under penalty of perjury and no true familiarity with the facts and circumstances. Karamitsos has not even seen the videotapes. If Glendora had the cable casting time, she would do reruns of these people. And I may do that yet. Karamitsos says, point 1. Now this is the so-called memorandum of law. Plaintiff's action should be dismissed pursuant to CPLR 3212 and or 3211A7, as she said about 7 times, as plaintiff failed to establish a cause of action. 1,700 tortious acts and injuries is not a cause of action. Yeah. For either intentional infliction or a negligent infliction of emotional distress. Dismissing an action is appropriate, she says, Karamitsos, when a plaintiff fails to establish a cause of action to withstand the defendant's motion to dismiss the test is whether liberally construing the facts in light most favorable to the plaintiff, do the facts state a recognizable cause of action. In this situation at bar, based on the pleadings, deposition transcripts, and voluminous correspondence from the plaintiff, it is clear that plaintiff has failed to state a cause of action for either intentional infliction or negligent infliction of emotional distress, and therefore plaintiff's action should be dismissed. Well, Glendora says the print is large, but the legal argument is tiny. To the Larkins, that is 49 pages and 171 tortious acts, and to these all the updates each week since November 1993 to January 1995, another 171 pages approximately, plus another 50 tortious acts. By no stretch of the lying of Karamitsos can it possibly be said no cause of action was stated. There are 4 causes of action, 250 counts. Second, upon the pleadings, deposition transcripts, and voluminous correspondence, it is clear that plaintiff has successfully stated a cause of action for intentional infliction of emotional disturbance with no physical effect. Insulting and abusive language, harassment, and violation of the White Plains Noise Ordinance. Third, there is no way a complaint can be dismissed when hours and hours of videotaped footage show defendants in the act of committing these tortious acts and proving what follows: that defendant's conduct was so outrageous and shocking as to exceed all bounds of decency as measured by what the average member of the community would tolerate. 2, that defendant's conduct caused severe mental distress to the plaintiff. And 3, that defendant acted with a desire to cause such distress or acted recklessly and under circumstances that made it certain defendant knew that mental distress would result. A complaint which purports to state a cause of action for the intentional infliction of mental distress need not plead special damages nor allege that defendant's harmful acts be motivated, folks, solely by malice. Here I am under 600 watts of light. Prove 1, that defendant's conduct was so outrageous and shocking as to exceed all bounds of decency as measured by what the average member of the community would tolerate. Well, we certainly have that. 2, that defendant's conduct caused severe mental distress to plaintiff. We certainly have that. And 3, that defendant acted with a desire to cause such distress or acted recklessly and under circumstances that made it certain defendant knew that mental distress would result. You've heard all of that, and you've seen all of that. Damages. Exemplary damages may be recovered in a common law action for intentional harm from mental disturbance and offense to a plaintiff's personal dignity. Now, Karamitsos says, A, intentional infliction of emotional distress in order to maintain a cause of action for intentional infliction of emotional distress. There are 4 elements which must be established and proven by the plaintiff. There must be extreme and outrageous conduct by the defendants, established and proven. There must be an intent to cause or disregard of substantial probability of causing severe emotional distress, established and proven. There must be a causal connection between the conduct and the injury, established, proven. The conduct must result in severe emotional distress, established, proven. Glendora says, Glendora has shown all of this in her depositions, pleadings, prior proceedings, and her affidavit. Next is her videotaped evidence showing defendant's sound and picture with evidence that defendant's conduct was so outrageous and shocking as to exceed all bounds of decency. You and I have done that. This is page 72. Karamitsos says the case law is very clear that in order to survive a motion for summary judgment, the 4 requirements above must be strictly construed and satisfied. New York has adopted the restatement of torts, second, requiring that liability will only be found against the defendants where the conduct has been so outrageous in character and so extreme in degree, established and proven, as to go beyond all possible bounds of decency and regarded as atrocious and utterly intolerable in a civilized community, established and proven. Glendora says she has done this. This court cannot dismiss this action without seeing the videotaped evidence. And besides, it's up to a jury to decide the emotional disturbance. Karamitso says the courts have repeatedly held that in order for a claim of intentional infliction of emotional distress to survive a motion to dismiss, the underlying conduct must not merely be injurious or malicious, but must reach a level that upon being presented with the facts, the average member of the community would denounce such conduct as atrocious, utterly intolerable, and beyond all possible bounds of decency. Glendora, this conduct by Larkins did. Viewers have done this, and so have friends said that this was beyond all bounds of decency. Now, Glendora has shown this in print, she's shown it on videotape, and she's shown it on TV. This has already been abundantly covered and proved. Who was a law firm for the winner for Wilson? Okie dokie. There was nothing but about Glendora's injuries that were threats, annoyances, petty oppressions, or trivial incidents. Glendora has people to say so. Maybe Kaplan did not have the evidence, but Glendora does. 11th point. There is no way this court can dismiss as big a case as this, or even a little case, with no evidence taken, no witnesses sworn, no testimony elicited, and no videotape seen. Nor does this motion deal with causes of action, insulting and abusive language, harassment, violation of the White Plains Noise Ordinance. 12th point. It is Sunday morning at 6:20 a.m. Let me give you an example of the guilt, and why this case must not be dismissed. Franklin and Glendora are in the basement putting their laundry in the washers. Glendora hears footsteps. She goes to the cellar hallway. Coming down the stairs is Daniel Walsh. He was on his way out the front door, but he heard us in the cellar in the laundry area. So he goes out 180 degrees out of his way and comes down through the laundry area deliberately to harass us. We, as always, said nothing to him. He said, "Have you sent out any letters today?" We said nothing, as is our strict policy. We said that. He said, "That was a nice letter you sent." We said nothing. Walsh crossed through the cellar, went out the east cellar door, walked around the building to Greenwich Avenue, the direction he originally was going. He went out of his way just to 1, inflict emotional disturbance, 2, harass us, and 3, to speak insulting and abusive language. 13th, how Karamitso's cries, how the reports on TV make these defendants and the subjects of jests. Yet they go on with their tortious acts. Cause and effect. If they don't want to be on TV, then cut out the law-breaking. The cause is their law-breaking, as Daniel Walsh did in coming through the cellar. He wanted to pick a fight. The effect is reporting it on print and on TV. There was nothing about Glendora's injuries that were threats, annoyances, petty oppressions, or trivial incidents. 14th, outside our front door now for 4 days is a Glendora wall log torn into 30 pieces. Prime suspect is Daniel Walsh. Even though Glendora has picked up 55 grocery bags of litter around the buildings and grounds, she will not touch the litter Daniel Walsh, prime suspect, put there. Let him pick it up. It looks terrible. If they don't like the reports of their bads in print and on TV, then stop the bads. Daniel Walsh has to be under the influence of some substance to do what he did at 6:20 a.m. on a Sunday morning. Normal people would not do a thing like that. He broke 3 laws and he has to pay. This case must not be dismissed. Justice has to come before coddling. How? Now I can't go down cellar to do laundry Sunday at 6 a.m. without concern about being attacked by Daniel Walsh. It is now 7:16 a.m. Sunday morning. Before church, Glendora will try to do more on her cross motion. We have worked 21¼ hours so far on this paper. This emotional disturbance is not a cause of action pursuant to CPLR 3211A7. Glendora says no way. And that would be no cause of action, that I have no cause of action. Ridiculous. Lawyers do not contest the facts. There is no dispute that the Larkins did what they did. It is a matter of indelible record in print, on videotape, on TV, and in viewers' memories. To say that these lawbreakers did not intentionally inflict emotional disturbance with no physical effect is foolish. Such lying is a waste of court time and the taxpayers' money. If you can't see that this is intentional infliction of emotional disturbance, you don't belong on the bench. Kara Mitzels, what she writes is stupid and outright devious, deceptive, degenerate, and disgraceful. Any fool can see on the printed record alone and the deposition minutes that this is not the case. Kara Mitzels lies in not mentioning the egregious acts that exceed all bounds of decency as measured by what the average member of the community stands. Kara Mitzels' record for stealing the truth stands forever here in print, on videotape, and on TV. Glendora really doesn't care that much about negligent infliction of emotional disturbance with no physical effect. The intentional infliction of emotional disturbance with no physical effect is so enormous, it overshadows negligent infliction of emotional disturbance with no physical effect. Glendora is not withdrawing as a cause of action negligent infliction of emotional disturbance with no physical effect, but if she did, she would eliminate Koza Cousins, Conboy Odell, McGrath, and Kara Mitzels as the lawyers for Andrew and Kevin Larkin, because their insurance policy, general accident, covers negligence. If Glendora withdraws a negligence cause of action, then Koza et al. Are out. Justice Etner refused defense of Daniel Walsh. General accident was physical, and Glendora's cause is emotional. And that is page 80. This is from the insurance company, Etna Insurance Company, to Daniel Walsh. And it says, since summons and complaint alleges that Daniel Walsh, Roberta Walsh, and James Walsh's intentional acts caused the plaintiff mental and emotional disturbance, as well as mental anguish, we must respectfully deny coverage and our duty to defend this lawsuit, as the alleged bodily injury was not caused by an occurrence, but rather than the intentional acts of Daniel Walsh, Roberta Walsh, and James Walsh, which is specifically excluded as outlined above. So, just as Etna could not defend Daniel, Roberta, and James Walsh because of non-bodily injury and because of being intentional instead of accidental, that's exactly what general accident should have written to Andrew Larkin. And this is why I figure that Koza, Conboy, Cousins, Wilson, Babe, Odell, McGrath, Kara Mitzels, I feel that they are in fraud. They are acting fraudulently because they really shouldn't be, general accident shouldn't be paying to defend Andrew and Kevin Larkin, because Andrew and Kevin Larkin were committing intentionally, not accidentally, these injuries, and they were committing non-bodily injuries, not bodily injuries. When are the Larkins, Walshes, Alpucci's, Koza, Conboy, Cousins, Odell, McGrath, Kara Mitzels, Carlucci, and Judge Wood going to awaken one day and hear their God and see all the evil they have done, repent, ask for forgiveness, and atone? When are they going to have their religious experience? When are they going to earn back their souls? When are they going to do their penitence? Here are two seniors minding their own business, living lives for good in their home, and boom, their peace, quiet, health, emotional, and mental well-being, repose, comfort are shattered on the second holiest day of the year by 4 law-breaking juvenile delinquents and their 6 law-breaking parents. It has cost them 500 hours of labor, it's cost the senior citizens, destruction of their income, devastation of their free time, obliteration of their protected interests of freedom from mental disturbance, stress and strain on their 40-year marriage, dwindling of their senior citizen bank account, reduction of their church activity, and stealing 500 hours of their time, which, excepting for Judge Wood, is a lot shorter than what they have, abusing a D-Day veteran. We didn't have time to clean our home this week, as we always do on Saturday. We didn't have time to do our end-of-the-week finances. We have not had time to work on our income tax return a little every day, as we usually do, starting the New Year's Day. Don't you people have any conscience at all? Don't you go to church or temple? Don't you ever stop and face your God? About Kara Mitzels, B1, defendant must breach a duty owed directly to plaintiff, Glendora says. Freedom from mental disturbance, intentional or negligent, is a protected interest. Here is the law. Freedom from mental disturbance is a protected interest. Damages may be recovered on a cause of action for emotional disturbance. New York law allows recovery for mental disturbance in the absence of physical impact. It results in an immediate physical injury. May be had. There is no requirement that the force proceed directly from the defendant to the plaintiff. Although fraud, extra litigation, and a measure of speculation are possibilities if recovery is permitted for fright, this is no reason for a court to eschew a measure of its jurisdiction. Andrew and Kevin Larkin, pursuant to this law, inflicted emotional disturbance. Glendora has proved that freedom from mental disturbance is a protected interest. Glendora can recover damages. New York law allows recovery for mental disturbance in the absence of a physical impact, and you are under oath, Judge Wood, to carry out New York law. That is your job. Andrew and Kevin Larkin had a duty toward Glendora to refrain from negligently inflicting emotional disturbance with no physical effect upon Glendora. They had that duty. They breached that duty. Glendora proved they breached that duty. They had a duty not to cause all the noise they did, not to yell, shout, hoot, and holler under bedroom windows so as to annoy and disturb our quiet, comfort, repose, health, and peace in our dwelling and residence. They had a duty not to insult us and to sling abusive language at us. They had a duty not to engage in a course of conduct and repeatedly commit acts which alarmed and seriously annoyed us and which served no legitimate purpose. They had a duty toward us not to vandalize our property, not to invade our property by climbing the outside wall and peering into our bathroom window. New York adheres to the majority view that there may be a recovery for this tort committed by Andrew and Kevin Larkin. To this recovery, Glendora is entitled. A dismissal would be the work of a fool. The breach of duty endangered Glendora's physical well-being and safety. One day, Kevin was inflicting emotional disturbance upon Glendora with a big yellow ball until under Glendora's south bedroom window. Glendora was looking out the window to protect herself. Theo Alpucci came along, grabbed the ball, and threw it at Glendora's head, cracking 3 window panes. This is on record in the White Plains Detective's office. Glendora could never leave her apartment or enter it without fear for her own physical well-being and safety, that of her 75-year-old husband, her car, and her home. Glendora has proved this repeatedly in print and deposition on videotape and on TV. When Franklin served summons or delivered the logs, Kevin Larkin would tell his father Franklin was in the area. One time, Andrew Larkin stood outside his apartment door with truculence. Franklin was afraid, and this made Glendora afraid. It is serious business. Glendora is a nervous wreck. Franklin is a nervous wreck. His being so intensifies Glendora's being so. Defendant's motion, Karamitzel's rights for summary judgment should have been granted, dismissing plaintiff's cause of action for negligent infliction of emotional distress. The court held that liability attaches only if the defendant engages in extreme or outrageous conduct which is substantiated and results in harm or fear of physical harm. Well, Glendora has shown that Larkin liability attaches because the Larkins engaged in extreme and outrageous conduct which has been substantiated in print by a witness on videotape and on TV, and which resulted in harm and fear of physical harm. The case law is in favor of not dismissing. After long lists of lofty citations, judges rule by the seat of their pants anyway. A judge ought to be able to absorb the facts, know what is just, and rule accordingly. Give justice to the right and make the wrong pay up. There is a duty. Larkin's breached it. Glendora has proved it. Let's go on to certify this case ready for trial. Karamitzel says, however, even if a duty did exist, the plaintiff's physical well-being and or safety have not been endangered. And Glendora says this is wrong. And that Karamitzel says, nor has the plaintiff testified as to any fear for her own physical well-being or safety. Glendora says again, wrong. And therefore plaintiff has failed to satisfy any of the necessary requirements to maintain an action for negligent infliction of emotional distress. Glendora says she is wrong again. And Karamitzel says, in conclusion, is respectfully submitted to the court that plaintiff has failed to state a cause of action for either intentional infliction of emotional distress or negligent infliction of emotional distress, and therefore plaintiff's action should be dismissed. Glendora says plaintiff has succeeded in stating and proving a cause of action for both intentional infliction of emotional disturbance and negligent infliction of emotional distress, and therefore defendant's motion to dismiss should be dismissed and Glendora's case should be certified ready for trial. Let's have some justice here instead of all this lying and fee sucking. Carol Mitzel's lies again. It should also be noted that no cause of action exists against defendant Andrew Larkin, as plaintiff testified that he is not engaged in any direct actions against the plaintiff and cannot be held liable for negligent supervision of his minor son Kevin Larkin under these circumstances. But Glendora says this is a lie. Andrew Larkin intentionally inflicted emotional disturbance with no physical effect upon Glendora by A, allowing his son Kevin to do so, and B, encourage him to do so. Neither Andrew Larkin nor his wife Patricia ever showed any signs within Glendora's view of disciplining their son to cease and desist. Andrew Larkin is liable, and this afterthought tacked on insertion by Kara Mitzels is no defense. He is held liable for negligent supervision of his son. This is such a bad parenting record, Kara Mitzels et al. Just dig the record in more deeply. I would not want a record like that standing up for wrong. Would you folks? Lying, covering up. What happened to good old confession, repentance, contrition, atonement? You learn these things in church or from your parents. What hope is there with these parents? And Kevin has a whole life before him. It is really very It is 9 a.m. now. We have to go to church. We have worked for 24 and a half hours on this paper. After church, we went to a meeting of the Center for Judicial Accountability. It was all about bad judges. There were 30 people there, and we were out to reform the courts. And these 30 people listed the horror stories of what bad judges had done to them. Glendora says nobody can call this action frivolous. More than 200 injuries by the Larkins upon Glendora and more than 1,700 from all three defendant families. What is frivolous is the drivel written by Koza, Conboy, Cousins, Odell, McGrath, and Karamitsos. Nobody can call this case without merit except a lawyer who makes his living lying. The defense is without merit. There is not an iota of merit in this defense, as plaintiff has shown. Defendants have no defense and never will have. They cite a case, and it's really weak, and Glendora says, is this the best case they can find to support their outrageous motion? We don't have to worry about waste of judicial resources in the Westchester County Courthouse Tower. It was shut down for a week from Christmas through New Year's with all of those clerks and all of those judges loafing. Reduce expenses in opposing frivolous claims, Kara Mitzo says. Well, lawyers and judges are not interested in reducing expenses. They like them. Kara Mitzel's motion for sanctions and expenses is as groundless and meritless as her defense. Glendora opposes it. Glendora hereby makes a cross motion to sanction lawyers Koza, Conboy, Cousins, Odell, McGrath, and Kara Mitzel's for 1A, a frivolous defense, 2, an outrageously long and rambling paper, costing Glendora and Franklin so far 24 and a half hours of connubial bliss, 3, obstructing justice. Judge Wood should have sanctioned Koza for lying about Larkin's new address and Conboy for not providing his insurance agreement. Glendora motioned this, but Judge Wood protected the Wilson Bay law firm, and he probably will do so again, and we all know why. We have worked on this paper 30 hours. It is 6:45 p.m. For 45 minutes. James Walt's son has been outside our south bedroom window on his roller skates, going back and forth, whistling and digging the tip of the roller skates perpendicularly into the asphalt, making as much noise as he could, and he is doing what his father did at 6:20 a.m. At 6:20 p.m., James Walsh, his son, was doing the same thing that his father was doing at 6:20 a.m. on a Sunday morning, trying to pick a fight and breaking those laws. Intentional infliction of emotional disturbance, breaking the White Plains noise ordinance, and harassing. This case is not frivolous, but Kara Mitzo's is, in addition to being interminable. Should be sanctioned. She has written the 20 cause of action. That's the 25th and 6 lies. Glendora's case is tremendously meritorious. Karamitsos should be sanctioned for being so prolix. Glendora has stated a cause of action. Karamitsos has not stated a cause to dismiss. Karamitsos right, but she has been advised of this and still refuses to discontinue the claim against the Larkins. Well, if lawyers come up, if lawyers come up and advise you to drop the case against them, and I don't do it, what law is broken here? That's not even plain common sense. Glendora demands proof as to she has been advised. This is like Odell's lie that Koza et al. Made a motion to Judge Wood to stop Glendora from videotaping and audiotaping the depositions and cablecasting them. There never was any such motion. So Karamitsos comes up with your proof. How can anybody repeat wrong information over and over and be so prolix? So come up with your proof. Glendora will never discontinue her case against Larkin until justice is done. Karamitsos right even after they moved out of the premises and in fact out of state. Glendora, this is an abomination. This is the worst lie yet. Out of state is a juicy lie, and on this alone Glendora should win her cross motion. They haven't moved out of state, according to the United States Post Office. They live at 68 Condit Street in Harrison. They haven't moved out of state, according to the Harrison Police Department. Andrew Larkin is still a police officer at the Harrison Police Department. Andrew Larkin still works there. They haven't moved out of state, according to the log Glendora sends every week to 68 Condit Street, Harrison, New York. It has never been returned. Karamitsos must be sanctioned for lying, not for perjury, because she was careful not to declare under penalty of perjury. She was supposed to declare under penalty of perjury, but she didn't because she was lying all the way through this paper. We see why she submitted an affirmation instead of an affidavit with a notarized jurat. She just signed it. No notary. Karamitsos right. Furthermore, the plaintiff continuously has enclosed relevant sections of McKinney's in her weekly newsletter, which delineate the torts or requirements. What is she saying now? I really don't know. She is so disjointed. Glendora does not use McKinney's. She used CPLR. And the correct term is not logs. It's, the correct term is not weekly newsletters. It's logs. It's a listing of their tortious acts and of the personal injuries they are heaping. She mentions that Glendora said that Kevin was never obscene or vile. No, he wasn't, but he was insulting and abusive, and that is a tort. About obscene or vile, who can trust a lawyer? Glendora is good enough to say something nice about this juvenile delinquent, and Karamitsos turns it into a weapon. Glendora will never be that generous to these people again. Playful activities, quote unquote, is a misrepresentation. Glendora sets the record straight again. Covered cyanide for 3 obstreperous, undisciplined, captious, obnoxious, violent, law-breaking, injury heaping, foul-mouthed, profane, obscene delinquents who have no respect for society, neighbors, adults, D-Day veterans, the United States of America, the sacrilege of the Star-Spangled Banner 3 times, not for the state of New York. The conduct is so outrageous in character of Kevin and Andrew Larkin and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. I could never understand a police officer sinking to the language that Andrew Larkin did. Go on, Andrew Larkin, telling your lie and ruining your life and that of your sons, pulverizing your own self-respect. Karamitsos says, in addition, the plaintiff has not sustained any injury or threat or fear of injury, nor has she sought any treatment of any nature. In fact, the plaintiff has not alleged or proven any damages. Glendora says, repetitive lie. Glendora has proven damages. Will Karamitsos ever stop? This nonsense has gone on for page after page. Karamitsos says yet another and more compelling reason warranting the imposition of sanctions is the plaintiff's conduct itself. Glendora has never acted frivolously. Karamitsos is not only frivolous, but too childish and immature to be taking up the court's time. The paper goes on, vexatious and repetitively vexatious. When will Karamitsos ever mature? I really think that Kevin Larkin wrote this paper. Karamitsos, aware of the plaintiff's outlandish and irreprehensible conduct throughout these proceedings. I don't think there's any such word as irreprehensible. Pursuant to CPLR, Glendora demands specificity. What, where, and when was outlandish and irreprehensible, whatever irreprehensible is. Karamitsos, from outright attacks on the defendants themselves, most of whom are young children and their playmates. Substantiate any such attacks. Who made the attacks? The defendants and the children themselves. Glendora never attacked. Glendora never even spoke to these people from the time they started breaking the laws on April the 12th, 1993. Playmates, quote unquote, is chocolate-covered cyanide. The right word is accomplices. The videotapes show this graphically. Karamitsos, to personal harassment of defendant's insurance company chief executive officer at his residence. Again, let's try to teach Karamitsos the meaning of harassment. A person is guilty of the offense of harassment with intent to harass, annoy, or alarm another person when he engages in a course of conduct or repeatedly commits acts which alarm or seriously annoy another person and which serve no legitimate purpose. Glendora had a legitimate purpose. She is a shareholder herself and does not like to see her class ripped off, in this case by the greedy Koza gang. Karamitsos, the court, your firm, its office, the Harrison Police Department, and even the governor of the state of New York have all been verbally abused and slandered by the plaintiff for no reason. Supra is unsubstantiated. What law was broken? Karamitsos is unprofessional enough to call this a memorandum of law? I don't remember slandering or verbally abusing the governor of the state of New York. And which governor would it be? Pataki or Cuomo? Karamitsos, it is obvious from her correspondence, the most recent copies of which are attached here too, that the plaintiff has nothing better to do all day than sit and videotape the co-residents in her condominium complex. Well, this is so puerile. Karamitsos should be sanctioned for being frivolous, vexatious, and repetitively vexatious. Kevin Larkin, orphaned by his parents, had nothing better to do all day than intentionally inflict emotional disturbance upon Glendora, use insulting and abusive language, harass Glendora, and violate the White Plains Noise Ordinance. Karamitsos calls her paper a memorandum of law. Correspondence, quote unquote, is an ignorant misnomer. Logs is the term. The videotaping happens when the law breaking happens. You would think Karamitsos and defendants would know that by now. Apparently they never learn. Karamitsos says, so obsessed is this woman with causing grief to others. Can you imagine putting this into a law paper, let alone put into a so-called memorandum of law? If she had not learned what this case is about by now, there is no hope she ever will. Karamitsos is grossly unqualified for the job Wilson, Babe, Conboy, Koza, and Cousins gave her to do. When Glendora told Judge Wood January 18, 1995 about the videotapes and mentioned Odell, Judge Wood said with a frown, "Who's Odell?" Glendora thought to herself that that's okay because Odell doesn't know who Judge Wood is. Odell called Judge Wood Judge Howard Wood, not Judge Harold Wood. This law firm has bungled from the beginning, including their default of not answering timely and being 34 days late, which Judge Wood never should have let go by. Karamitsos says that she has now commenced eviction proceedings against the other defendants in this matter, her co-tenants, and she proudly writes they should be gone just as the Larkins have gone. Glendora, what law was broken? This is repetitive and vexatious. This unduly prolonged and washed-out impropriety of Karamitsos is frivolous. This droning on with this baby stuff abundantly proves to the court Karamitsos cannot find a defense. This is hardly a memorandum of law. There is no question the Walshes and the Alpuccis must be evicted. They have violated landlord's rights and Glendora's rights under the Real Property Actions and Proceedings Law and under the Real Property Law. They should be gone just as the Larkins have gone, quote unquote. That is not proudly, quote unquote, as inanely as Karamitsos babbles. And what law is broken here? Karamitsos says, going to sleep? Isn't that nice? She was asleep in the chair and then she came to join us with the videotaping. What a good kitty. What a good little kitty. Yes. Good little Ginny cat. Karamitso says, if this is not an indication of malicious and frivolous conduct, then what is? Isn't that a great statement for a lawyer? Boy, just think of it. 3 years of law school, 4 years as an undergraduate. It is not, but this paper by Karamitsos is. This egregious conduct, Glendora says, mandates that the maximum amount of sanctions allowable by law be imposed upon Alexander Karamitsos. Further, she should go back to law school, or the affirmance office, quote unquote, should teach her how to write a memorandum of law instead of talking like a little child indistinctly and meaninglessly. A message should be sent to Alexander Karamitsos to write a grown-up legal paper if she wants to address a judicial forum. Also to learn what a personal vendetta is, a tautology if I ever heard one, and what a meritorious cause of action this is. That should never be a period. That's an incomplete sentence. Okay. Karamitsos, conclusion. Glendora says, we are grateful. As frivolous and vexatious as it is, we are glad to see it. The conclusion. Part 3, Alpha. Now that Glendora has finished answering the trivial trash of Karamitsos, 7 p.m. on January the 22nd, 1995, Sunday, Glendora writes to draw judicial attention to the insulting and abusive language of law-breaking of Andrew and Kevin Larkin. 1. When Franklin served Andrew Larkin the summons with notice and complaint, upon which Wilson Bave et al. Defaulted by answering 34 days late, Andrew Larkin said to Franklin, "She's an idiot, and you are too." When Glendora came downstairs to go to her cellar locker, Andrew Larkin, with Kevin standing behind him, said to Glendora, who never has said anything to him in her life, quote, "Don't SCREW me, I'm doing the FU*KING laundry." Kevin Larkin said to Glendora when she came into the laundry room another time, "Ding dong, the wicked witch is dead." Kevin Larkin said at another time as Franklin and Glendora were leaving Building A to go to TCI to edit a chat with Glendora, "Look guys, the circus is leaving town." Here are the law and the cases on the same. New York adheres to the majority view, which holds that insulting or abusive language can be actionable if it is sufficiently outrageous to a person of ordinary sensibilities. Both where the language is alleged to have caused purely emotional distress to the person to whom it is directed, and where the language is alleged to have caused emotional distress, which in turn produced some physical injury in the person to whom it was directed. It has been said that even in the absence of a contemporaneous bodily impact or injury, this is from American jurisprudence, folks, or of acts constituting an assault, a cause of action is properly predicated upon a mental or emotional disturbance or upon a bodily injury or illness resulting therefrom, which is produced by disturbing utterances such as profane, insulting, humiliating, or abusive language. Gamma. Here's a copy of the White Plains Noise Ordinance that Andrew and Kevin Larkin violated on approximately 100 counts. That's cute, Ginny. Ginny's turning on her back and curling her little hands. Just a cute kitty. This artificial, oh yeah, the White Plains Noise Ordinance, there it is. And here's the part that's slanted, that's the part that slanted, that yelling, shouting, hooting, whistling, or singing on the public streets, parks, or places, or a place of business or other establishment open to the public, particularly between the hours of 10 p.m. and 7 p.m. That's not our part. Here's our part. Or at any time or place so as to annoy or disturb the quiet, comfort, repose, health, or peace of persons in any place of work or in any dwelling or other residence. That's the White Plains Noise Ordinance. This artificial separation of Larkin defendants from Walsh and Alpucci takes the Larkin law-breaking out of context. This prejudices Glendora, and she takes exception to taking the Larkin tortfeasing out of the context of the entire lawsuit. She just flopped. Now, these defendants, in addition to having broken state laws, have broken federal laws. The federal laws, fright, shock, and emotional disturbance with no physical effect, is very good. The discussion and cases in American jurisprudence fit Glendora's case like a glove. A, federal court is faster. B, federal court is cheaper. C, discovery is swiftly dispatched. D, at the same time, Glendora can include the violation of her civil rights by the pro-Cousins Judge Wood Court, and deal with Paul Carlucci's pro se prejudice, spite, and malice. Just as Glendora sued Cablevision in state court for breaking a state law and in federal court for breaking a federal law, she can sue the Larkins in federal court for breaking a federal law. And here it is. And as I said, it is very, very good. You know something, Ginny?